Elon Musk's social media platform, now known as X, has lost a court battle over former President Donald Trump's direct messages. So this relates to his direct messages that he may have sent on January 6th. So last year, Special Counsel Jack Smith had asked the company to hand over Trump's direct messages from his presidency without telling him, due to it being a criminal investigation. Okay, Elon Musk, of course, refused, and lawyers for X spent the last year arguing that the gag order on this was an unconstitutional prior restraint on X's speech and a, quote, end run around a record law shielding privileged presidential communications. So, now they ended up taking this case all the way to the Supreme Court, which then rejected it. Oops. Now, why? Now, Smith told the court that X's contentions lack merit and warrant no further review, and the SCOTUS seemingly agreed, which is very interesting. Now, the government had argued that its non-disclosure order was narrowly tailored to serve a compelling interest in stopping Donald Trump from either deleting his DMs or intimidating witnesses engaged in his DMs while he was in office. Until, of course, in January 20th, right? When he became a private citizen. So now, I think those were two concerns that were warranted, given what we know about Donald Trump and how he would, delete his DMs. That is, of course, if he had been able to access his Twitter account, which got banned after January 6th. Okay, but Twitter itself, now X, still had the records. So now, under the Stored Communications Act, the SCA, the government can request data and apply for a non-disclosure order, which would gag any communications provider from tipping off an account holder about search warrants for limited periods deemed appropriate by a court. So, yes, this was limited. X was only prohibited from alerting Donald Trump to the search warrant for a period of 180 days, and only restricted from discussing the existence of the warrant itself, which means this is not technically a freewheeling censorship case, as X claimed. Like, oh, this is complete and total censorship. You are stopping me from being able to do my First Amendment rights to tip off Donald Trump. Wait, there's certain reasons for it. The government also warned that affirming X's appeal would mean that no SCA warrant could be enforced without disclosure to a potential privilege holder, regardless of the dangers to the integrity of the investigation. Which, yeah, that's a compelling argument, right? So that's a good argument by the government to say, look, if we do this, then it kind of neuters the SCA, right? And then, you can't really use it. And you're going to tip people off. They're going to delete their messages and things like that. So we don't want to do that. Now, here's the thing, though. I am a privacy advocate. Okay, so I do care about this. That said, this doesn't necessarily mean that communications that are involved in criminal activity or could be involved shouldn't be looked at, ever. No, there just needs to be a process, right? The government needs to make a really, really good case that they should have access to these private communications. That's all I'm saying. Now, that said, I don't think Elon really cares about that, about privacy. I think he cares mainly because of who this crime is connected to, right? And that crime, of course, is related to the communications that he did on January 6th to people, calling for example, I should say egging on the crowd during the insurrection, okay? But look, Elon Musk has given Donald Trump millions of dollars so far. That's what we find out. And he obviously wants Trump to win the election. Okay? He has a vested interest in this. All right? That said, while I agree with the case against Donald Trump and parts of the government's argument, there are some things that I do have concerns about. Okay? And I'm gonna go through those. For example, in a brief supporting X, attorneys for the nonprofit digital rights group, the Electronic Frontier Foundation, wrote that the court was, quote, unduly dismissive of the arguments X had raised and failed to apply exacting scrutiny relieving the government of its burden to actually demonstrate with evidence that the alternatives they presented would be ineffective. So what were those alternatives? Basically, they were asking for a representative that would be capable of asserting whether some of the data requested was privileged data or not under the Presidential Records Act, which I think would be a fair ask, okay? I'm not sure why the Supreme Court had refused that. I mean, yeah, I don't see a problem with saying, okay, we got to make sure your communications are not privileged. Like, for example, attorney-client privilege, right? What if he was talking with his lawyers? Okay, that makes sense, okay? It does. Now, X also argued that none of the government's arguments for non-disclosure made sense. Not only was Smith's investigation announced publicly, which allowed Trump to ample time to delete his DMs, okay, but also that there was no risk of destruction of the requested records because Twitter had preserved them. All right. Now, the government also admitted that calling Trump a flight risk was implausible because the former president had already announced his intention to run for president again. All right. So, yeah, that makes sense. A bit of a strange rationale by Smith's team. But that said, I don't trust Elon Musk not to delete those records. Or, did these records suddenly disappear? Oh, the server room suddenly caught on fire. I don't know what happened. I don't trust him at all, considering how he's in the tank for Donald Trump. So there's an open bias here that I get very concerned about. That said, because court cases do establish precedent, right? And if this is taken as a test case in the government seizing potentially privileged information from social media, then yeah, it's concerning that the court was just like, no, we're not going to hear any arguments. This could happen not just to Donald Trump, but this could happen to journalists as well. So that's pretty much my main concern here. Journalists and average people could get caught up in this. Okay, it's not as if the government has never spied in on its own people. Okay, absolutely, or profiled people. Absolutely. Look at what happened to Muslims after 9/11, right? All this surveillance, and so this could apply to digital surveillance as well. So in seizing their records to see whether or not they are terrorists. So yeah, that is my concern, right? Now that said, in its position for SCOTUS review, X pointed out that every social media or communications platform is constantly bombarded with government data requests. Not only the platforms themselves can challenge. So that leaves it up to the platforms to figure out when the data requests are problematic, which apparently they are, oftentimes. Now, the government, as a result of these being problematic and overly broad, the government often agrees to modify or vacate them in informal negotiations. Now, in this case, the government refused to negotiate at first. Now, if that happens, the platform has to decide whether the litigation is worth it, risking sanctions if the court finds the platform to be in contempt. So now X was sanctioned about $350,000 in the Trump case. Now, they argued that if there's a less restrictive alternative deemed appropriate by the courts, then platforms would not have to guess when the data requests threaten to expose users' privileged information. And I think that is a valid concern. I know, it's true. But it's not like Elon Musk cares about the average person here or definitely cares about journalists or anything like that. No, he cares about Donald Trump. He cares about himself. That said, his motives here don't make some of the arguments any less valid. All right. In fact, what the government did actually ended up making his arguments invalid. So now Smith was able to convince the court that X's challenge to his non-disclosure order was moot because the government had agreed to modify the non-disclosure order to disclose the warrant to Donald Trump, so long as the name of the case agent assigned to the investigation was redacted. So good move by Smith here to say, okay, all right, you're going to challenge it. That's fine. We'll tell Donald Trump that the warrant is coming, right? That it's here, that we're taking his data, but we're not going to let him know who the case agent is, so he cannot intimidate or threaten that government worker. That great compromise on that one, okay? Now, additionally, the government argued that this case would not be an appropriate vehicle for SCOTUS's review of the question X raised because, quote, no executive privilege issue actually existed in this case. So, look, that once again, good move by Smith and a good argument. But that said, I'm not saying X doesn't bring up some valid concerns. They do, it just doesn't apply to this particular case. Okay. Now, that said, EFF lawyers noted that the government already has far too much authority to shield its activities from public scrutiny. And that's fair. By failing to prevent non-disclosure orders from restraining speech, the court system risks making it harder to meaningfully test these gag orders in court. Yeah, I mean, how do you challenge a gag order in court if you don't know that that the social media company has given your data over to the government and now can't tell you? So again, that's a fair argument. They said even a meritless gag order that is ultimately voided by a court causes great harm while it is in effect. While disclosure ensures that individuals whose information is searched have an opportunity to defend their privacy from unwarranted and unlawful government intrusions. And so, again, there's two things at play here, and both things are pretty important. And again, the questions are, how much power does the government have in taking somebody's data and then gagging the social media companies, preventing them from telling you that the government has taken your data to seize your private communications that could be, used as evidence for a crime? I think there does need to be protections in place for users, obviously, privacy protections. And I also agree that, yeah, the companies should also have some protections as well. Finding the company, holding them in contempt for saying, hey, we don't want to release this personal, this personal data for X user. Okay, I don't want to have to pay to be found in contempt for that. You know what I'm saying? Protecting my user's privacy, because if I don't protect their privacy, then they're not going to trust our platform. Okay? But again, you shouldn't have to be afraid that your data is going to be taken by the government without you knowing about it to be used against you later. But at the same time, the government does need to be able to have the tools to investigate crimes. If they involve social media, if they can get evidence of said crimes from your social media interactions, your private messages. And so there is, again, both sides here have legitimate points on this. And so it makes it a pretty nuanced and thorny issue. Again, because we're talking about constitutional issues, we're talking about the privacy rights here, but we're also talking about being able to allow the government to do its job, to allow law enforcement to do its job as well. And so these are considerations that have to be discussed and litigated through so that we can find, hopefully, a good balance of both concerns. Thank you for watching. If you enjoyed this video, please like, share, subscribe, hit the bell icon in order to get notified whenever a new video is released. And if you want to support independent, progressive media through this difficult time where it seems like everybody is shutting down, you can become a member on our YouTube page, you can become a subscriber on Facebook, or you can go to my Patreon. It's patreon.com/Jeff Waldorf. Thank you.